Hi, I'm attorney Ben Schwartz, and today we have my colleague Rob Collins, also an attorney with the law firm of Schwartz and Schwartz, with us. Today we're going to get Rob to answer a frequently asked question, and you have no idea how frequently we actually get asked this question because we have a lot of clients that try to handle things themselves, and when they have to deal with insurance adjusters from the at-fault driver's insurance company, or from the owner of the biting dog's insurance company, or the adjuster from the premises owner's insurance company. In slip and fall cases, they find out what a pleasure it is to deal with bodily injury liability adjusters. And so they end up coming to us, and they always ask us a question, and it's usually some variation on the same theme. Here's the question. The question is, I tried to handle my own personal injury case. I got a settlement offer from the at-fault party's insurance company. The settlement offer was $750 or $1,000 or $1,200 or $1,500. Why is it that when I try to handle my own personal injury claim, I get offered some, puny, insulting settlement offer, but when you go to a personal injury attorney and they do it, they get thousands or tens of thousands or hundreds of thousands of dollars in the form of a settlement offer? Rob, do you have any thoughts on why that is?
Sure. Basically, the insurance company is a business, and the job of a business is to make money for its investors. So it is only going to pay out the bare minimum necessary to get your case to go away. The insurance company is not scared of you. The way that we look at cases is not from the beginning forward to trial. We look at the cases from what is likely to happen at trial and work our way back to set that up.
That's exactly right.
And so when we get these great offers from the insurance company, it's because they can see what is likely to happen at trial. Whereas when the average person handles one of these cases, they have no idea how to set the case up for trial. They're hoping not to go to trial. The insurance company they train their adjusters to be very friendly and nice on the phone, but really what they're trying to do is get as much information out of you as possible so they can use it against you. And you are giving them information that they will use against you without even knowing it. Just by not having an attorney, you are giving them information. You're telling them that either you think this case is a small value case, and that's why you're not going to get an attorney, or that you don't want to get an attorney. You don't trust them or something. For some reason, you don't want to get an attorney. From the insurance adjuster's viewpoint, looking at trial and working their way back, that means that either you would try to take this to trial yourself, which would be horrible for you. There's a very good chance that the insurance company would pay out zero at trial just because the average person doesn't know how to file a complaint, file motions, respond to motions, take depositions, get a report from an expert before the expert report deadline, cross-examine the defense expert, cross-examine people at trial, make opening arguments, closing arguments, get everything into evidence that needs to be put into evidence before the jury even gets the case. If the average person tried to do all that, they could just mess up on one step and the case is gone forever. So from the insurance company's viewpoint, they're not scared of you taking this to trial. They'll probably end up paying out zero. And they also know that when you don't get an attorney early on and try to handle the case yourself, if you try to go get an attorney, let's say you tried to settle the case yourself, it's 2 weeks before the statute of limitations is up, or a month, or whatever. Now you're going to have a very hard time getting an attorney to take on your case. We don't want those cases where it's right before the statute of limitations because we don't have the police report. We don't have the medical records. We don't know whether this is a case that we can be willing to take all the way through to trial if necessary. We just don't have enough information. And the insurance company knows that. Some other things that you can tell the insurance company without even realizing it. Let's say you try to make a demand on your own. Well, if you demand too little, you just told them that you don't think the case is worth anything. If you ever make a demand to the insurance company and the adjuster says, "Sure, sounds good, I'll get that release right out to you," well, you just screwed up big time. The insurance company obviously thought your case was worth more than that.
Yep.
So you just left a whole bunch of money on the table because you didn't know what the case value actually was. And if you make a demand that's just outrageous, well, like I said, they're not scared of you. They know you're not going to get that if you try to take it to a jury yourself.
So, as you're talking, I'm thinking about this one case I had. Rob, I was admitted to practice law in December of 2001, and as we're sitting here recording the video, it's now December of 2016. So this is my 15th anniversary as a practicing personal injury attorney. And in 15 years and thousands of personal injury cases, I've had one case that I can think of where a lady came to me and she had received an offer from the insurance company, from the at-fault driver's insurance company, to settle her case. And when she came into me, it was such a good offer that I did not think that she should hire me, because I did not think that I would be able to get her significantly more. I thought I could get her more, but not enough more to make it worth her while to hire me and pay me a contingent fee. And so I recommended to her that she go ahead and settle the claim on her own and not pay any attorney's fees. That's one case in 15 years, and I have to tell you that that's the only one. I can think of hundreds of cases where someone's come to me and they've tried to handle the personal injury case on their own. They've gotten an offer, and the award that I've been able to get them is 10 times or 20 times or 30 times what was offered. And I can also think of cases where other attorneys who do not primarily handle personal injury cases have hired me as trial counsel for their clients' personal injury cases. In other words, they have brought me in as co-counsel, and I know you've had this experience too, where the award, the settlement, or the jury award that you get is many multiples of what the offer was that original attorney got from the insurance company. And, it's not unusual to have a car accident case or other type of personal injury case where the attorney handling the case, maybe they don't specialize in personal injury cases, maybe they don't specialize in going to trial and, picking juries and doing opening statements and, like you said, cross-examining witnesses, giving closing arguments. And when they hire a trial lawyer who's used to doing that and who has the chops to do that, they find that the settlement that the insurance company was willing to offer can be twice, 3 times, 5 times as much as what the insurance company was willing to offer when it was just, that general practice attorney handling the case. And so, I couldn't agree with you more. I think that if you want to avoid war, the best way to do that is to prepare for war. And if you want to get a good settlement, whether it's a good settlement while the case is pending in a court or prior to even filing the lawsuit, the best way to do that is to get somebody that's really good at giving closing arguments to juries, because that is how you maximize the case value.
Sure. Now, I can think of one client myself where I said, look, don't hire me.
Mm-hmm.
It was a lady who had gone to the ER. I think she had some x-rays, and that was it.
Yeah.
And I think they had offered her like $2,000 or $3,000.
Mm-hmm.
And I said, look, you hire me, I'm not going to, once you account for the attorney's fees and costs, just take it.
Yeah.
I mean,
Well, Rob, I think that one of the major things that prevents people from going to an attorney for their personal injury case is the perception that the attorney's fees are going to eat up their settlement, and or the perception that the costs involved in litigating the case or pursuing the case are going to eat up their settlement. And so people want to keep 100% of what they can get for themselves. But at the same time, what people need to understand is our job is to evaluate cases. And if we evaluate your case and we say 100% of what you can get yourself is going to be more than the 2/3 that you would get if you hired us on a contingent fee basis and paid us a third, we're going to tell you that. We have no interest in taking something and leaving you in a worse position than when we started representing you. We only want to take cases where we're adding value to the client and doing something that the client couldn't do for themselves. So, something to think about. You have any other thoughts on that?
I believe there are several studies out there showing that the plaintiff with an attorney ends up with more money in their pocket at the end of the case than when they try to handle the exact same type of case on their own.
Sure.
So.
Not surprising. So, I'm attorney Ben Schwartz. This is attorney Rob Collins. We're both with the law firm of Schwartz and Schwartz. Our main office is in Dover, Delaware. We also have an office in Wilmington, Delaware, which is where we're recording this video right now. We also have offices just outside of Philadelphia, in Havertown, Pennsylvania, and in Salisbury, Maryland. If you have a question about a personal injury claim or case, feel free to send me an email, ben.schwartz@schwartzandschwartz.com, or you can find us on Facebook. Go to facebook.com/schwartzandschwartz. You can send us a message through the Facebook page, or you can leave a comment on one of our video blogs on the Facebook page. Thanks for watching.